lawsuit that is has been filed in federal court, which challenges our sign code regulation. As you know, the City of Miami, we prohibit outdoor advertising. We prohibit billboards. However, pursuant to state law, we have the authority, and in fact, we have, through various settlements, entered into settlement agreement with companies that had existing signs. And obviously, in order to advance a very compelling interest that we have of making sure that we achieve a net reduction in the number of signs throughout the city, while promoting our interest in the aesthetics and the safety that comes about with the reduction of outdoor advertising. So this is a settlement agreement. You know, we have filed our defenses to the action, and we feel very strong about the constitutionality and the validity of our law, but we do recommend the settlement because, as with all cases, you can never guarantee the outcome. And we wouldn't want anything that would impede our ability to continue to promote the interest that we have in the aesthetics of the city and the safety of the city by the reduction of signs. Now, this settlement agreement achieves that. It reduces the net number of signs. The reason for the substitution is that previously we had Clear Channel Outdoor, Inc. as a party joining in the settlement agreement because the plaintiff in this case didn't have the requisite number of signs in order to achieve the net reduction that we wanted as part of the settlement. Since we had prepared the settlement and distributed it to you, South Florida has acquired an interest in the sign that Clear Channel was going to bring into the settlement mix. So they no longer need to be a part of the settlement agreement. So the changes to this agreement really only concern the fact that Clear Channel is no longer a party to the agreement. So anywhere in the agreement that previously we had reference to Clear Channel, it is no longer necessary. I have read it, and in fact, it achieves that purpose. The only other change that has been made is in page 15 of the agreement under subsection 11, and that is just to expressly provide that in this agreement, each party will bear its own cost and attorney's fees. And that was something that had always been negotiated and agreed to. We just had not expressly provided it for in the settlement agreement. So we are inserting language in there to provide for the following. So having put that on the record, I recommend the settlement agreement. The business terms of the agreement and the logistics of it, Vanessa can explain.
Okay, this is a settlement agreement that will resolve.
Sir, you are?
Vanessa Acosta, Assistant Director of Building and Zoning. This is a settlement agreement between the City of Miami and South Florida Equitable Fund to resolve the federal lawsuit, as our city attorney mentioned, and other related issues. In trying to follow the guidelines of our existing ordinance, we asked that the company provide us the 2-for-1 takedown that is required by all of the other outdoor settlement agreements. We have achieved that for this agreement. We are only allowing for one additional billboard to be put up. The net takedowns and billboards existing in the city will not be changing. This is 2-for-1 takedown in our continued effort, as was expressed by this commission, to continue taking down billboards throughout the city.
Thank you. Public hearings. Well, this is a resolution. It's not a public hearing, but I'll allow you to speak.
Thank you so very much, Mr. Chairman. My name is Grace Olares, Vice President of the Roads Association. I'm sure you may remember, I'll go as quickly as possible. 8 months ago, I wrote you a letter when this matter came before you with respect to an LED, and I told you that the Roads Association opposed the LED because that was what the application stated. Just yesterday, I found out that Mr. Echemendia has been making some representations or innuendos that Grace Olares has a personal interest in your denying this action because I work for a firm that has an interest in this particular deal. Mr. Echemendia came to my house on a specially set meeting of the board of directors of the roads, and he made a presentation to the board of directors of the Roads Association. After he left, there are 2 members of the board of directors that are attorneys and had questions and I didn't know the answer. Therefore, we call the firm I work for, and then my boss gave the answers. We hung up the phone, and they commenced a debate about these issues, whether LED or this or that. The conclusion was that the Roads Association moved in its entirety to oppose any signs, whether it's LED or no LED, within our neighborhood. Is a visual pollution. It is terrible. Mr. Biao, who was the one who moved, will say, I am going to be looking at the back of a billboard, whether it's lit or not, from my home. Can you imagine the ones living next to it? There is already one for the vodka Ultima on the other side of, let me finish just 1 second, Mr. Chairman. There's another one that may be less than 1,500 feet. In any event, I want to put on the records that Grace Solares, on behalf of the Roads Association, opposes any signs, LED or any, on behalf of the Neighborhood Association, whether if it's Mr. Echemendia, God, or Mr. Obama, who comes here requesting. Thank you so much.
Thank you. I'm going to let you this time. 2 minutes.
Thank you, Commissioner Nathan Curran, 3132.
Helps.
3132 Day Avenue. First of all, I would like to thank the Assistant Director of Planning and Zoning. I'd never heard the term streamlined monocle before. That's a new one on me. Commissioner, I'd just like to reiterate what Grace Solares said, and commissioners, I am aware of at least 5 cities in the state of Florida that do not do 2-for-1 trades, they do 10-for-1 trades. So my first comment is that I don't understand why we're settling for a 2-for-1 trade when there are already precedents for a 10-to-1 trade. Secondly, I would like to reinforce what Grace Solares said. I don't believe that we are actually downgrading in terms of signs, because when you have a sign that can change its message every 8 seconds, if we take that out to the extreme, we're talking about taking down 2 signs and putting up 32,000. So it's a bit deceiving to say that we're actually getting less signage when, in fact, if these are changeable LEDs, we're getting more signage, not less. So I would like to ask that you members of the commission keep that in mind, and at the very least, as we go forward with, I'm sure, what will be more billboard issues, visual pollution issues, that you contemplate perhaps going to the higher range as opposed to this lower 2-for-1 range. Thank you.
Thank you.
Commissioners?
Questions?
Yes, is the public hearing closed?
No, it's not public hearings.
You just allowed them?
It's individuals to speak because they've been sitting here all morning.
I'll let Ms. Acosta continue.
The 2-for-1 takedown was in following with the past practices set in terms of what would be taken down. It's a total net effect of billboards coming down in the next years.
Now, my understanding, Mr. Costa, this has been ongoing for a few years now?
We've been attempting to reach settlement negotiations for over a year.
Okay. Thank you. Vice Mayor.
Mr. Chairman, that one sign happens to is proposed to be located in my district. I think it's called the 79 site. I agree with Mr. Solares, and I agree with the residents. I don't think that it's an appropriate site for a billboard. And I am opposed to this, and I respectfully request, just like I yield to your all judgments in your districts just a little while ago, that you respect my wishes, and I cannot support this location for a billboard or an LED at this time.
Gentlemen, there are actually alternate locations also mentioned in the agreement should the 7-9 site not be acceptable, where this may be relocated in an effort to achieve a settlement with this party to avoid any further problems.
The alternate locations are not in my district. I could tell you, I am not in support of this location, the 79 site, which is on 1700 Southwest 3rd Avenue or 299 Southwest 17th Road. I am strongly opposed to this site at this present time.
The alternate site locations were in the original package that you guys received with the agenda.
I believe it is the Tanaka site, 570 Northwest 67th Street, or the Elks Lodge site, 4949 Northwest 7th Avenue. There's one more site, 4291 Northwest 7th Avenue. Now, question. It seems like a little while ago, I asked about NEA payments. I didn't read anything about any NEA payments.
In this agreement, I tried to take an amalgamation of the past 3 agreements and try to mirror this as much to Carter, CBS, and Clear Channel's agreements. This came closest to Carter in terms of numbers, and I asked them in an effort to deal with the visual plight to come up with the more expensive poll, and that was the loss on the NEA payments. They actually are close enough to the other agreements.
How close?
The numbers that were taken were actually percentages after adding the numbers owed by all 3 other agreements. And then I did some math to figure out more or less what would be the amount based on the amount of signs, the amount of time that's gone into it, this, and all of those factors.
Any other questions? Do you have any problem with the change of alternative sites?
I have a couple questions, Mr. Chairman. One question is this an LED billboard?
No, it's a static standard billboard.
That's what I thought. I just wanted a clarification on the record. I just want another clarification, and I think maybe Ms. Solares may have to make the clarification, which is she stated on the record that she opposes this site and that the homeowners opposes the site. And just for her own purposes, since there's been apparently, according to her, a claim that she has a conflict, that she opposes also the site that her firm represents. I just want her to clarify that on the record. Or that the association, better said, not you
Yes, sir,
personally.
because it
right.
so happens to be in the roads section.
So
It happens to be in the
I know.
roads section.
I just want a clarification.
Both, okay?
Yeah.
But the thing is that if this document that I have not seen, the people have not been privy to that document, new document or old document. I never had it. I was supposed to have had it, but they never sent it to me. I said, so now I don't know, I mean, where these things are. I'm talking on behalf of the Roads Association today. If these other sections that they're applying for, if, I mean, you would like to make an opposition to that, I don't even know where they are. If it's next to a neighborhood association, it's fine. But as far as this one is concerned, is the Roads Association, it's the roads area.
And maybe I wasn't clear. I'm sorry if I wasn't. I didn't mean for you to opine on the other 2 alternative sites. What I meant was there's been a contention that you stated that your firm, the firm that you work for, represents a site that is nearby. And I just
Correct.
want you to be clear on the record, because you just made a very broad statement. that
Clear
you're gonna-
on the records that the Roads Association is opposed to any billboard
Right.
in our neighborhood.
Right,
Coming
including the
from
one-
him or anyone else.
I think that's pretty clear.
Thank you.
Thank you, Ms. Solares.